Item number
What do you want?
9 of the combined market release. Your lordship already passed an order that two wives, the dispute between two wives regarding the pension, my lord, since 2007, my lord.
What do you want, sir? What do you want? What do you want?
Upgradation, my lord, any day.
Sorry, no upgradation.
Can you see the, my lord, your lordship's order?
Yes.
Your lordship's order, can you see?
Yes.
Otherwise, my lord, they are not getting pension, my lord.
Yes, there are many other like you. Yes.
Let it, my lord. Then your lordship kindly
Keep the
release the matter,
inclusion.
my lord.
Any other inclusion?
Release the matter, my lord.
Yes.
Then to mention,
Take down an order. Learned counsel prays that the matter may be released. We have got an order today.
Is the order of reinstatement and pressure. During the pendency of the state petition, the department reinstated and started pressing. So nothing remains in the petition. I just beseech your lordship, it could be taken because earlier occasion this matter was taken up. The petitioner Union of India did not turn. The matter to have to direct the matter to turn on Friday, coming Friday. Subject should be again, automatic adjourn motion.
What is the number of the case?
I just set down ending up on a scripts before you.
So it has to be dismissed as infructuous.
Yes, so though my lord, I am the respondent, and you once again put them on notice.
Unless they are here, how it can be done?
Once again put them on notice. Then my lord,
All right, let it be listed on Friday at the top.
already mentioned, but I was apprehending it could go on the bottom.
No, if we have accepted the slip, then it will be.
Seconded, sorry.
All right, listed at the top. Give the case number.
The case number as well as my lord.
Yes.
সেবার অর্ডারটা দিয়ে দিচ্ছি দেখুন এই তো
Mr. Paul was mentioned earlier, there was a oral objection by your lordship that the matter would be appearing on 14th, 14th of July. Well, this is a hearing matter.
Give the slip.
Without notice, I am mentioning.
Give it. We'll see. Just place the file. What is the order? Let us place the file. Let us see what is the order.
Item number 153.
Your Lordship, I appear on behalf of the state.
Compassionate appointment. My prayer was rejected on the ground that at the time of Mallard's filing the application or at the time of demise death of the employee, I am minor. So on that ground, my prayer has been rejected.
Your grandson?
No, my lords. I am the son.
Son.
Only son.
You are not even 8 years old. How your prayer can be considered?
Only one thing. The employee died on 2010.
Died on?
6/4/2010.
Yes.
My mother made the application on 3rd of May, 3/5/2010.
Yes. In your favor.
Yes, ma'am.
And you were 7 years, 9 months.
Yes.
Yes.
At the time of filing this application.
What can be done?
The only thing is that because they are supposed to apply the notification that is applicable on the date of the application.
26 EMP gives you at best 5 years. Even if that 5 years is granted, you will not get any.
Only my argument is that 26 AMP come into force on 2016.
We are saying even if 26 EMP is allowed, you will get a 5 years only.
My
This still you will not cross the age.
My argument is that there is no such provision in the notification that is applicable on the date of the date of the employee. The 26 EMP restricted to 5 years.
What is the meaning of 5 years?
My argument is that it restricted to 5 years
5 years from which date?
from the date of the employee.
From the date of
Date of the employee.
death of the employee, correct? So even if 5 years is allowed, you will not cross. That is precisely what we are saying. You are 8 years. Even if 5 years is allowed, you will be 13 years.
My argument is
Although that agreement prima facie doesn't appear to be acceptable. But even if you say that this 26 EMP has to be applied and with effect from the date of death of the employee, because it does not, the intent of 26 EMP is clear. It says it will apply even to pending cases. But even if we apply it, it is of no avail to you. If you had been 15 years, then maybe this argument would have helped you. But you are not.
The thing is that, there are judgments of this honorable court which says, my lord, that the notification applicable on the date of the employee should be applicable.
We are saying we accept that even you will get nothing. That is precisely what we are saying.
If your lordship kindly
If you get 5 years, what will be your age?
I am not saying 26 EMP. They have considered my prayer prima facie on the notification that is applicable on the date of the employee. Thereafter, yes, at the time of death of the employee.
Sir, we are saying even if you are claiming benefit of 26 EMP, even if we hold that yes, 26 EMP is to apply in your case, still it will not help you. You will get 5 years and that will bring you to 13 years only. Can you get a job in 13 years?
Only thing is that, if your lordship kindly comes to the reply there once, I will take just 1 minute, not more than that. Page 34.
Yes.
Their reply, they have said, subsequently, employment process was started in respect of the applicant hearing in the light of the notification number 30 EMP dated 2 2nd April 2008 and with 114 EMP dated 14th 8 2008. So, my lord, in that cases, the condition is that immediate assistance should be required. There is no such provision that it should be restricted to 5 years.
All right, that's enough. Yes, take down.
May I refer to this notification for once? It should be
30 of
30,
2008.
30 read with 114.
Yes. So there it was only 6 months.
Within 6 months, the application should be made. I made the application within 2 months. And there is no such provision that it should be restricted to 5 years. That is why.
No, but there is no such requirement that he should be a major.
No such requirement.
No. Read 30 MP.
Such provision. That is why. That there is no such provision in 30.
Sir, please read 30. It says it has to be read with 301 and 303. So read 301 and 303. It cannot be read in isolation. The circular you are relying upon, it says it has to be read with 301 and 303. So you have to read 301 and 303. Inescapable. Now read what 301 and 303 says.
Dependency. There is no such provision.
So therefore, it should be offered at 13 years.
No, I am saying that it should be immediate assistance. It says after becoming eligible.
Just read. Where is the provision in 301 and 303?
301 says dependents of employees dying in harness.
Yes.
It says a solely dependent wife, son, daughter, near relation of an employee who dies in harness, leaving his family in immediate need of assistance.
Yes.
A near relation of the deceased employee may be considered for employment on compensation cover. I am not reading that, that will not be relevant.
Yes.
Second is dependents of employees retiring incapacitated. This is also not relevant. Persons belonging to family of land loser, this is also not relevant. Exemptions employees is also not relevant. This is 301.
Yes. And 303?
Says no.
It's for 3 of 2. 303. 303.
It's also regarding dependency. 303.
You have to go through all the memorandums prior to 2008. In between 301, 303 to 2008. Because 301, 303 has been consistently amended and altered. Yes, all these will have to be
Your Worship,
read.
may I come submit? Your Worship, the regulation or the EMP that has been relied upon by the petitioner clearly indicates that an application has to be made in the prescribed pro forma. First of all, Your Lordship, the application was made on in a plain paper. It was a plain paper application by a widow who herself was eligible for the candidature, Your Lordship. Despite being eligible, she chose to make an application for a 7-year-old son in 2010, seeking an appointment for a period when he will be eligible for the post. Your Worship, by the time he was eligible for the post, the 2013 regulation had been given effect to, Your Lordship. And in terms of the 2013 regulation, it clearly says any pending application has to be
He is on one ground. He says that time 2008 was applicable. He has made his application under 2008. It has to be considered.
Yes, Your Lordship.
So 2008 has to be read with 301, 303, which has been amended so many times.
Your Lordship.
It's not possible to go through all of this in 5
Your
minutes.
Lordship, my submission is 2008 EMP shall not be applicable in case of this petitioner because at the time of application, the son was not a major. He was a 7-year-old boy.
So therefore shows the requirement that
The
unless these
attaining the age of 18, Your Lordship, a 7-year-old cannot be given an employment.
no, he cannot be, but can he be in the queue? That is what he is saying.
If he is in the queue, his application has to be considered at the time when he is attaining the age of majority, Your Lordship. Your Lordship.
Therefore, we are saying that 301, 303 has been amended n number of times. One of these must be having it. You must, both of you, you have also not seen. And you have also.
Your Lordship, my submission was that 2008 EMP does not even apply to the petitioner because at the time when the petitioner was had attained the age of majority, the 2013 regulation has come in.
Where is 160?
It cannot be given retrospective.
160 EMP.
160 EMP. I have to check.
That was clarifying 301 or 303, 160 MP. I don't remember the date, but it is of 2006, I think.
Yes.
Twenty-seven 10/2006. 27/10.
$160 MP I do not have with me right now. Which I shall come back then. But my
27/10/2006. It is 27/10/2006. Have you found it? This is about 2 years prior to your father's unfortunate demise. And it is effective from 1/11/2006. By the same department.
No, this is
For the same purpose.
something is that this says in I'm reading for your.
Please read.
Inviting a reference to the instruction write serial number 1 of your official circular number such and such dated such and such regarding underage registration. I am directed to say that government has since decided that the minimum age of registration of the job seekers in the employment exchange
Yes.
This is, my lord, in employment.
So that minimum age has come into effect. On
This is related to registration of employment.
Yes. No. For the purpose of, please read. Prior to this, there was a scope. Up to 14 years, it was to be granted.
Yes, my lord, in
From
employment.
this, it has become 18 years.
This
So
is,
therefore, there is no employment below 18 years.
this is for employment exchange.
Correct.
Registration.
Employment, whether compassionate or regular, there is no employment below 18. This is specified in 2006. This cannot be overlooked. The scheme you are relying upon does not say that this will not apply. And this is otherwise the law also. A minor cannot be appointed. Can it be just think to say that if somebody is not on school,
Lordship. Lordship will kindly
and is there
consider.
a finding that the mother was otherwise eligible?
Your Lordship, I shall show from the document, Your Lordship.
Let us see. Because if what he is saying we accept, then even if a child is 1 day old, his application can be made. And for 18 years, they will have to wait for him to attain majority
Lordship,
before he is offered an appointment.
I shall show Your Lordship two documents. Page 26 is the ID of the deceased employee. Date of birth is somewhere 1976 or 70. Your Lordship, when Your Lordship, the deceased employee died, he was hardly 40 years old.
No. You said the mother was eligible.
Mother was otherwise eligible
How
by
do you know?
age, Your Lordship.
No, age is not the
Your
only
Lordship, the
criteria.
husband who died, he was
Age is the only criteria.
no, Your Lordship.
So how do you know that she was eligible?
Even if he was not 8th pass, he was eligible for Group D stuff. In any event, she could have applied for herself.
For Group
First-
D, even 8th pass is not required.
So Group D, Your Lordship, the minimum criteria for a higher post is 8th pass. Below that, Your Lordship, she could have applied. And Your
Can't be.
Lordship will kindly see.
For Group D, 8th pass is required.
Your Lordship will kindly see 2013 regulation, Your Lordship.
What is the 2013 regulation?
She will kindly see good 2013 regulation for once.
What is that regarding?
Regarding Your Lordship, the clause 7 clearly indicates that all the departments will furnish number of all undisposed case in the
We
proforma.
are not on 13. He is saying he is to be covered by 8. We want to see that even if 8 is applied, what he will get.
Even if 8 is applied, he could not have been given the employment in 2010.
That ground
because
is
he was
not
7
your
years
ground,
old.
which you said that the mother is eligible. There is no finding to that
No
effect.
finding to that effect.
So therefore, don't say that.
That was not even the pleading of the mother that I am not ineligible. I am
When
ineligible.
you rejected, you could have arrived at a finding.
I rejected.
Where is the rejection order?
I rejected on the ground that he was.
Where is the rejection order?
I shall come.
31.
31.
Page
31.
31. Where the authority applied 2013 and 2016 regulation.
paging is all messed up, sir. Impossible.
P6, page 31.
All right. All right, we'll consider. Anything else? Huh?
Lordship will dispose it of.
We think so.
Unless there was one more opportunity.
Therefore, we are asking you, what do you want? What
30
else?
30 MP. Your lordship has shown me 160 MP. 30 MP has says that the governor has now been pleased.
30 EMP,
Yes, my lord.
the one that you are relying upon.
Yes.
Yes.
Yes, my lord. One, two. 7 lines from the top. The government had been for some time past considering the necessity of reviewing these provisions. After careful review of the matter, the governor has now been pleased to rescind the notification number such and such, along with corrigenda orders notification issued in the context of the said notification, and restore the position which was prevailing prior to the notification notification 97 EMP dated to 6/6/2005. So, 160 EMP is of 2006. So, if it is restored the position before 2005, 160 AMP may not be applicable.
No, 160 EMP is 2006, sir.
Yes, my lord. If it says that it's restored the position before 2005,
Yes.
160 AMP came into force on
EMP
2006.
is 6/6/2005 issued in the context said notification. What are you saying? Just let us see.
I'm just saying
Right, understand. Just let us read, sir, please.
I'm sorry.
Understand. Yes, so 97 EMP has been rescinded.
Is that it restored the provision before 2005.
Yes, whatever is in 97 has to be ignored. For that purpose, the earlier position is restored. So how does that help you? 97, we take it, it is gone.
It has once my contention is that 160 AMP came into force in 2006.
No, 160 has not been rescinded. It says 97 has been rescinded along with its corrigenda orders notification. There's a specific, that is the specific mandate of this,
And it says,
nothing more.
it says restore the position
Correct.
which was prevailing.
Obviously, because once it is rescinded, it has to restore.
Rescinded prevailing prior to the notification numbers of 2005.
Obviously, yes, yes, because it has been rescinded.
But 160 MP is of 2006.
Huh?
160 MP is of 2006. So,
So-
if it says is restored the position before.
So we have to take that all that has been issued, whether irrespective of 97 is gone. That is your submission.
My submission is only that.
Yours, that obviously that is your submission. 97 is gone, that means everything is gone.
I am saying
Because position is restored of 2005.
before 2000.
So everything is gone, whether specified in the notification or not. All the EMPs are gone now.
If
That is a slightly a very difficult submission to accept.
160 MP,
Yeah, that's enough. Yes. Ordinance counsel for the petitioner and
154.
পাঁচ তারিখে my lord, before my lord.
সিমিলার ম্যাটারে ওনারা ইয়ে করেছিল যে ইন্ট্রিম অর্ডারের এগেনস্টে এসেছে
My lord,
Yes,
my lord,
because there was 6 matters previously, so in some matter they have got a stay. We approached this court, learned advocate appearing for the respondent in this case said that this is against an interim order. So this is also an again in this case they have been rejected. Matter was fixed yesterday, my lord.
my lord,
Learned advocate made a submission, there is no urgency. In
may-
those matters,
may I
your lordship
submit
has passed a direction that the matters will be disposed of without granting any
before you-
unnecessary adjournment.
my lord, I want
Court
to
is of
say,
the
my
opinion,
lord,
since there is
I
no
am-
specific,
I am withdrawing this
direction.
matter.
Oh.
Document order is issued.
My lord, let me submit, my lord, what I have to submit. I am withdrawing the matter. My lord, I have instruction from my lord advocate on record. The matter has been fixed before the tribunal on 5th of August.
8th both
on the 5th of August.
5th of August. My lord, withdrawing, my lord, only, my lord, the matter to be heard by the division bench because it is a promotional posting order.
We don't know. That is for the tribunal to take a decision. There is no requirement.
challenging the promotion.
Sir, the law is clear. L. Chandra Kumar has clearly laid down. It's not required. Plus, recently our division bench has passed an order in RV 376. 376 of, what is that case number? 376 of 24 or 25?
Review.
Yes, because some matters were disposed of by an order which said that since a single judge of the bench administrative has passed the order, so that was subsequently reviewed. The tribunal is well within its jurisdiction. Even a single member can decide.
But my lord, come to this judgment, my lord, so far.
But we are not going to express anything because section 6(5) is there under the Administrative Tribunals Act. You take an appropriate. You should be showing it to us and we are showing to.
Number is very good, 376.
376 of 24.
376.
After the learned advocate, Mr. Which matters? So OA number changes, date is same. Date is same. Give the OA number in the next case, 155.
Seven zero. 700 তারপর এটা কত? এটা 700 লাস্টে
155. OA number, sir. Can you give?
107
No, no.
122.
701
The next one is
701
701. OA number 701.
Item number 1.
I beg to appear on behalf of the appellants in this matter. Appellants, sir.
You are the applicant before the tribunal.
This is an appeal from Group 6, Lordship. Assigned before your Lordship.
Motor vehicles.
This is, I'll just recapitulate before your Lordship. On the previous occasion, when your Lordship has taken up this matter, Lordship has gone through that order impugned, Lordship. What has happened is that the writ petitioner respondent was deployed in the tunnel gate.
In the
Tunnel gate, Lordship.
tunnel gate.
Tunnel gate. Tunnel gate is a specific gate which has two openings. Rather, one in gate and the other one was the out gate. Now, admittedly, this petitioner respondent.
What do you want?
Respect to my learned friend. My lord, this matter relates to challenging an order of the trial court's order, whereby trial court allowing the order in favor of the writ petitioner. Against that order, my learned friend's client preferred an appeal before the division bench. That matter was taken up by the my lord, court number 8, sitting in Justice Harish Tandon, along with Justice. Thereafter, my lord, due to the elevation of the bench, my lord, and Chief Justice of the Odisha High Court, the matter was lying pending. Upon our prayer, the matter was assigned before Lordship, and today, Lordship will direct my learned friend to intimate my learned, so the matter can be heard and heard by Lordship.
So you have
Track
been,
of the matter.
so you have been intimated.
Lordship. My lord, we are, my learned friend intimated us that the matter was assigned before Lordship, and we are coming before Lordship for just. But this is the backdrop of the matter.
Yes.
Now, if I may recapitulate, Lordship. Now, admittedly, the writ petitioner respondent was deployed at the B shift, that is specifically on B shift.
Please let us see the charge memo. Come to the charge memo.
Charge memo is at 86, page number 86 of my stay application, Lordship.
Before going to the main matter of the case, my lord, as my learned friend move memo along with the stay applications, my lord, as your lordship take up the final hearing, my lord, subject to kind sanction, my lord, stay was granted in favor of my learned friend. To the lordship
It has
present,
been elapsed, Lordship.
my lord, subject to kind sanction, my lord, a short brief note to be given before lordship respective party on the basis of your lordship can dispose the matter, because only the question of law is here whether the trial court can extend the benefit to the petitioner after set aside the order of dismissal, entire benefit. That order was harping my learned friend before lordship.
Oh, the Union of India is in appeal.
Lordship.
So the writ petition has been allowed.
Lordship.
Writ petition has been allowed
Lordship.
by the Honorable Single.
So let us see what is the infirmity in the single judge order. Tell us first. Yes.
My lord, should I not get, my lord, should I not get any chance to file any? brought objection within 2 weeks, 1 week.
No, no, why you are the writ petitioner, your entire brief is before us. What is to be filed?
No, Your Lordship. Your Lordship.
Everything is there.
Before the honorable single bench,
Lordship. Your Lordship, continue.
Union of India has preferred an affidavit opposition, though there was no affidavit reply was filed by the writ petitioner.
So no, we'll confine to whatever material is. We'll not go beyond that. Yes.
If I may invite your lordship directly to page number 305, paragraph 44 of the interim order, lordship.
Your Lordship.
In the analysis of the honorable single bench. May I, lord?
Lord, charge memo at page 163. Charge sheet. चार्ज शीट देखते चलें, चार्ज शीट देखते थे, चार्ज शीट देखिए, स्टार्ट 86 लॉस, 86 चार्ज मेमो, तुम बोला नहीं बोलो, कंटिन्यू करो. Yeah.
Yes. Charge memo is at 160.
It is at page 86, lordship. Dated 15th of October 2013. 36 of the CIS approved.
Was any presenting officer appointed?
They were presenting officer.
Where is the document showing appointment of presenting officer? In the charge memo, there is no reference to any presenting officer.
The brief of presenting officer.
Hmm? We have a doubt in this regard, therefore we are asking you. This is under CCS or there is a separate CISF?
CISF has a different set of rules. Inquiry has proceeded as per section, as per rule 36 of the CISF rules.
Therefore, what does section 36, what does it say? No presenting officer is required.
Takes up 3610B, Lordship. Inquiry authority shall, if the enrolled member of the force fails to appear within the specified time or refuses or omits to plead, the presenting officer to produce the evidence by which he proposes to prove the article of charge.
36?
3610B. Rule 3610B, Lordship.
If he fails to appear,
To appear, and
what if he appears? Then presenting officer is not required.
if there are any set of facts which are required to be proved, the article of charge, then in that case, presenting officer may be required.
So, can you conceive of a circumstance where it is not required to be proved?
In cases where, if I may say so, that by the prosecution witnesses, if the charges are absolutely proved,
So, who will examine the prosecution witnesses?
what is the inquiry officer?
Oh, please show from the rule that the inquiry officer will become the presenting officer. Is this inquiry officer is performing a quasi judicial function? He is to sit there and he is to hear the presenting officer trying to prove the case with reference to the evidence and witness. That is the law that we know.
Presenting.
How the inquiry officer can start looking into the evidence and witness? Cannot. So in this case, who is inquiring? The disciplinary authority or an inquiry officer?
Inquiry officer. Uh,
Now you please see 36(5)(c). Quite contrary to what you were just submitting.
in this case,
So where is the presenting officer? Show us. If he is not there, then everything is vitiated on this ground only.
I can take up page 154.
Yes, you the whole of it. Starts taking up evidence for its own. That case, this ground are sitting because he used to be there as a main person. No, some of the department. Yes, any reference to presenting officer?
Page 154. That is the brief of presenting officer, Lordship. It starts from page 154 of my stay application. Lordship. SS Mohanty, that is the assistant commander. As the presenting officer. Lordship.
All right, so there was a presenting officer. And on this ground, there is no challenge also.
I've got the original record of proceeding, Lordship. If I may present to your Lordship, the order.
No, it is there. If we wanted to be sure, now we'll tell you why we asked you this question. You please come to page 117.
The court witness. The court witness.
Just see what it says. Prastutikaran Padadikari Dwara. So it is a presenting officer, the presenting officer.
There were two court witnesses, Lordship.
All right. So this is no ground. What else? So what is the infirmity? Who has verified? See, the allegation is that while he was on guard, the truck bearing number so and so has entered without being checked, for which he is responsible. He did not check. If you come to the charge memo, the charge is sought to be sustained with reference to material which has been specified at page 89.
Lordship. The two.
Now, page 89, there are two witnesses.
Lordship. The PW1 and PW2.
PW2 and this one at serial 5. At best, these can be
recordings, Lordship.
These are the three which can be relied upon if they are positive to prove the charge.
Lordship. I will definitely have my all the evidences, Lordship. Now, before coming into the part of evidences, Lordship, if I would invite your Lordship to page 305, that is the impugned order, paragraph 44, Lordship. Why I am asking your Lordship? Because This is the paragraph where the Honorable Single Bench has supplanted his opinion, saying that the order of punishment was perverse. Paragraph 44 of the impugned order, page 305. Perverse, and there was lack of evidence, and did the inquiry officer or the inquiry proceeded on a preconceived mind.
Yes, so what is wrong with this?
Lordship, if your Lordship may kindly takes up page 97 once, Lordship. That is the security standing order, Lordship. Page 97, paragraph B, Lordship, the area of responsibility. This is the tunnel gate. First one, if I may, the location, tunnel gate. And where I'm relying is paragraph 6, the area of responsibility. The post is situated on the north side of the MD office. Nearby the gate, there are two water bring and south yard railway crossing. It is 400 meters from the MD office. The line thereafter, criminal may enter from this gate, Lordship. So there was a decided, and there was a security order to that effect, which which ought to be alerted the petitioner, writ petitioner, that all the entry vehicles should be thoroughly checked, the entry permit of the vehicle and occupants inside the vehicle, their security checks has to be thoroughly conducted, Lordship. This is the first set of documents. Or
Where is the statement of Ramnath? Come to statement of Ramnath.
Lordship, statement of Ramnath is page 99, Lordship. Page 101 is the type copy. Lordship. May I read?
We'll read, just read. And Sunil Rai?
That is at 106, Lordship. For your Lordship takes up the statement of Sunil Lordship. One question which I would like to invite you, Lordship, at 105, Lordship.
Just wait, let us see these two statements.
Page 105, 106 statement, and type copy is at page 107, Lordship.
And where is the, what are you trying to show?
Lordship, page 105. Trying to, question number 3, Lordship. Arrested criminals said that they entered through the tunnel gate. Then why did you not make them meet the head constable or in charge at the tunnel gate? The answer to that was all the 3 force members posted at second shift at tunnel gate, ASI Muhammad Alim, head constable R.N. Upadhyay and Ravi Kumar were presented before the authorized officer at the vehicle gate, Lordship. So this very well proves that who 3 of them, of the members, were posted at that relevant point of time. At tunnel gate, Lordship.
टनल गेट से प्रवेश किया है तब आपने टनल गेट के इंचार्ज हेड कांस्टेबल या कांस्टेबल को क्यों नहीं मिलाया? तुमने गेट का द्वितीय पारी में तैनाती
There has been a slight difference between the statement of PW1 and PW2 so far in respect of the make of the vehicle.
Yes,
And there has
that
been,
may not be fatal.
yes,
The registration number is the same.
there has been also a difference regarding part of the registration number.
Part means what? One digit is different, then the number is different.
30H and 40H. That was a clerical error.
Anyway,
It was-
that is what you will say. Yes.
Gotcha.
So where is the CCTV?
Gotcha.
Person who has introduced the CCTV footage.
The fourth witness, Kadam, his statement is at page 114, Lordship. And the type copy is at page 115, Lordship.
Who is he? How he has got the footage?
Lordship, he is the in charge. He was working for monitoring CCTV in that unit.
Ek Santri. So he has also not seen who it is.
Since
So neither this Ramnath is a witness. He has stumbled upon this vehicle, if at all. He has found 3 persons have run away. 3 he has apprehended. They have hexablade. He is saying that they are going to cut copper wire and take it.
pilfering copper
Wire. Now the second person, he doesn't know anything. Ramnath called him, then he came.
Gotcha.
Then he saw whatever is there.
Gotcha.
So there is now only one person else
There are
who was the CCTV monitor.
CCTV monitoring.
He also says Ek Santri. He doesn't know who that person is.
During his cross-examination, he said so. Lordship.
Let us see.
Page 118, Lordship.
Yes.
Question asked by the court witness. If your Lordship can kindly take up question number 2. Which force member gave permission to the vehicle shown in the CCTV footage enter the plant? He named the writ petition respondent.
CCTV फुटेज में दर्शाए गए वाहन को में प्रवेश की अनुमति किस बल सदस्य ने दी थी?
After question number 4, Lordship. Before entering the vehicle, how long did the vehicle wait? This shows, the answer of this question shows that whether the vehicle and its occupants were really checked or not. The said vehicle, before entering the tunnel gate, waited for about 10 seconds. From 1858-40 to 1858-50. That is 10 seconds only.
There were 3 persons posted. What happened to the other 2?
Lordship, the 2 persons, Ali, ASI Muhammad Alim, he was the overall superintendent of that particular gate, and with him, Head Constable Haren Upadhyay, he was also posted in the outer gate of that same area, but 2 member of the forces were acting as a superintendents to the petitioner, since they were hierarchy in position. Now, both of them, they have been compulsory retired after holding an inquiry under Rule 36 for the same charge offense. Their role was that they could not supervise or they failed or neglected in superintendence of the petitioner's duty. Now, I'll come to that because in the statement of the petitioner, he
So this, they have entered what premises? It is a unit, cantonment, what do you call it?
Lordship, they entered the plant area.
Plant area. So they are CISF personnel are posted in some plant.
Yes, yes, Your Lordship.
It's not their unit.
It is not their unit, Lordship. Since
So that plant has only one gate.
no, there are several gates, Lordship, but the place where they have been apprehended, from that the closest entry point was the tunnel gate. And when the 3 persons, when they have apprehended.
So this CCTV footage monitor, what does he say? Which vehicle has come through? What does he say about the vehicle? Forget about whether that has been checked or not. Which vehicle he is talking about?
Lordship, so
एक 4-wheeler.
4-wheeler. He has not specified.
एक 4-wheeler entry करता है.
150.
He is saying 1 4-wheeler. He doesn't know whether it is a sumo or it is a bolero.
He never specified in his questions, or other in the questions asked by the court also. Although there was one question, that is question number 4, which says that before entering the gate, the vehicle was stopped for checking for only 10 seconds, Lordship. Now, this is important because if the answer of this question vis-a-vis to the standing order, the security standing order, which says
Stop for 10 seconds. So what? Did anyone ask this monitor that the 4-wheeler that you saw, were any 6 people sitting in that vehicle? Or 3 people were sitting in that vehicle?
because, Lordship, my respectful submission before
We
Lordship.
are not asking submission, we are asking facts. Was any such question put? No such question was put.
No question, no such
Nobody
question.
has determined whether it is the same vehicle. There is a 4-wheeler. This 4-wheeler, whether it was empty and has been stopped for 10 seconds and allowed to go, or it was having 6 people still for 10 seconds, only it was stopped and let to go. There is nothing.
Because ideally, Lordship, a person sitting at a CCTV monitoring will not be able to adjudge how many people sitting inside the vehicle. Yes, the people.
How do you know? Unless you ask him and he says it is not possible, the resolution is not so high, which we don't expect. It would be a high resolution CCTV camera, very easy to see that how many number, at least you can see 2-3 heads. You may not be able to identify, but surely you would say that there is a person sitting inside or there is nobody apart from the driver. This thing cannot be presumed when a consequence, penal consequence is to follow. Either it is a case or it is not a case.
After Lordship, court witness number.
So apart from these 3 witnesses, there is nobody.
There is one more, that is the company commander, Lordship, that is court witness number 2. His statement starts from page number 120, Lordship.
How, what knowledge he will have about the occurrence? Nothing. He will only say that such and such person told me. That is all. The commander would not know anything about the occurrence. He may say that yes, At best, he can corroborate existence of a vehicle wherein 3 persons with hexablade have been apprehended.
Lordship.
Beyond this, he cannot corroborate it.
Being the company commander, he is also in a position to ascertain the fact that the petitioner was there on duty on which area and corroborate on the fact.
Petitioner has not disputed this. That's not required.
Petitioner has never disputed that.
So therefore, that is not an issue to be established that he was there posted. But the point is, he was posted with 2 other people. So whether he was standing there, maybe he has gone away for 5 minutes, told his supervisor, I'll be back in 5 minutes. We don't know. These things cannot be presumed merely because he is posted there.
Statement of defense, Lordship. The charge witness. It is at page 129, Lordship. Charged official, Lordship.
The applicant statement,
The applicant statement, Lordship.
where is it?
Type copy is at page 133, Lordship. But if I may down price of that particular statement,
133.
133, Lordship. 133 is the type copy. And the statement in vernacular, it starts from page 129, Lordship.
It's impossible to read. 129 is not legible, 130 is not legible, 132, 1 is not legible. How can anyone?
If I may kindly rely the statement.
So he has denied everything.
Lordship, two lines, specific lines in that particular statement. It specifically mentions that two of his senior hierarchies, that is ASI Muhammad Alim and Head Constable RN Upadhyay, has briefed him thoroughly regarding the duty of presided over the gate. Lordship. And this also is in line to the security standing order, which ought to have been in petitioner's knowledge. Because later on the later incident, he went on before the appellate authority, and he has never controverted that security standing order. But he mentioned that since he was new to this unit, that is why he was unaware of the duty, or rather, what to be functioned, what area or responsibility he has to function. He is not aware of that. That is absolutely controverted with his own statement.
See, whatever is the stand and finding before the inquiry officer, that is final.
Okay.
It is only based on that material that the appeal and revision forum is invoked.
Okay.
Or when they say that something has been omitted. There is no dispute. He says, I have come back from a Cobra training. I don't know what was the duty. I was allotted the duty at the tunnel gate, in gate. And then I was briefed by my two seniors what I have to do. Thereafter, I have checked all the vehicles. Not a single vehicle has passed my post without my checking. That is his stand.
That is his stand.
Yes.
If I may,
There's no question of him not knowing the duties.
No.
He is not saying that.
he's not saying that, Lordship. But if I may just,
Where is the inquiry report?
Lordship, before inquiry report, I would invite your Lordship to page 127, Lordship. One very question which was put to the company commander, Lordship.
Yes.
Just for my own satisfaction, Lordship.
Yes, yes, please.
It says that question number 6, Lordship.
127.
Page number 127 of the
Question number 6.
question number 5 and question number 6.
2-3 minutes. It takes 2-3 minutes.
Usually takes 2 minutes.
Alright. That therefore we said a driver coming in with a vehicle which is empty. Maybe he is in uniform. Nobody knows. So for 10 seconds he stops, he goes. What's the big deal?
But admittedly,
Unless it is an unknown person, a criminal, but CCTV monitor person has not said anything. He says one four-wheeler has entered. 10 seconds it was there. One sentry was there. He has not done any check. That is his statement. We cannot add to this. We cannot subtract from this. We have to go by it.
this is, if I may say so.
And there is no evidence, there is no material brought by the presenting officer to show that apart from the petitioner, the other two persons who were posted there, they have nothing to do at the gate. There is no witness, no material on this. Supervisory, what does supervisory means? They are to sit in some office, or they are to be there to supervise him, or they are to visit every 1 hour. We don't know.
They were to be situated on the gate itself. But the only thing which has to be there is that whether the petitioner is performing his duty to his reasonableness or not, that has to
No, whether he has committed any dereliction, that is to be established. So, yes, we are looking at it. Yes. So now we can go to the inquiry report.
Lordship. Inquiry report starts at page 163, Lordship.
So there is only one finding at 169, serial 2. This finding is the basis of his punishment. So this is with reference to which material this finding can be sustained, that one vehicle was permitted by Constable G.D. Ravi Kumar to enter into the plant premises.
So this is,
Which evidence supports this finding?
Lordship, the CCTV footage presented by the court witness number 1, Lordship. That is on record, Lordship. The TV footage is also there before your Lordship on that original record proceeding, Lordship.
No, we have seen it from here.
Lordship.
116, 117.
116, 117, Lordship.
It doesn't, nobody has said that Ravi Kumar was doing this. How this finding has been recorded?
Lordship can kindly takes up facts admitted, Lordship. That is at 167.
That is a perverse finding. There is no admission of any fact by the applicant. That is a baseless and perverse finding. We have seen it. No legs to stand on. Show us from which page, which answer he has agreed. Just see the admission that has been recorded. The charged official permitted the vehicle to gain entry. This is an admission. Where is this admission? This has been repeated at page 167, 168, and then at 169. Again, there is a record that video footage
I
produced.
believe that 167 and 168 is basically an error in photocopy. Both the pages are, I believe, same, Lordship.
Oh. Oh. Anyway, but that maybe that is the presenting officer's brief. So therefore, he is saying that this is an admitted position. This is not a finding. The finding starts later. This admission is the presenting officer's brief. Finding is at page 171.
Yes. Finding is at 171, Lordship.
Nothing. So, where is the appellate authority's order?
His order is at page 208.
Is the appeal part of the record? The appeal that he has filed? Copy of his appeal. Page?
That is at page 213, Lordship. Prayer for reconsideration, Lordship. Lordship can kindly takes up page 220. Appeal on behalf of the Constable G.D. Ravi Kumar, Lordship.
So Kadam was not cross-examined.
No, Lordship. Neither of the court witnesses were cross-examined, Lordship. However, the opportunity was duly rendered, Lordship.
Thereafter, he has availed a revisional remedy also.
Revisional order as well. That's from page 215, Lordship.
215. Before the appellate order.
215, Lordship. Revisional order starts from 215, Lordship. 21st of January 2015, Lordship. The appeal starts.
So the
Lordship, by the order of the by the impugned order, wherein holding or supplanting the opinion of the honorable single bench, the petitioner has been directed to reinstate with full back wages, Lordship. The period while he was not working, this is something which has to be considered, and so far in this respect, Lordship, I would be relying upon the judgment of Satyapati, Lordship, wherein the
he has been out of service for how long?
2013.
since 2013, Lordship,
13 to 25.
20
Till now.
still now.
25, therefore, 12 years.
12 years. This is 1995, 6 Supreme Court cases, 749, Lord.
Yes, what is it from this judgment that you want to highlight?
Paragraph 18. In view of the legal positions, would be established that the disciplinary authority and on appeal, the appellate authority being fact-finding authority have exclusive power to consider the evidence with a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view
Paragraph 18.
paragraph 18. The
A review.
behind is that the punishment shocks the conscience of the honorable court for the appropriate rendering appropriate punishment. It should be remanded back to the authority who should consider on its effect of merit, Lordship. In the exceptional, in a very, very exceptional and rare circumstances only, the court should mold the reliefs, Lordship. My respectful submission is that considering the gravity of situation, Lordship,
Yes, this is on the quantum of punishment.
The quantum of punishment. I am relying specifically on that because when the when
But the High Court has not substituted its opinion on the punishment. It has said the finding is unsustainable.
finding is unsustainable,
Yes.
since it is the findings are perverse
Perverse, not with reference to any material.
and the inquiry proceeded on preconceived mind. So based on 3 counts, the inquiry was completely set aside.
So it is not a case of the High Court substituting the penalty or deciding that for such and such grave punishment.
My contention is that there was no lack of, although there was certain glitches of evidences, I must say.
We are on this, that why this judgment? 18 paragraph, how it covers you say that the finding is sustainable. Inquiry officer's finding is sustainable. This is not on that point.
No,
This is on the point of whether the High Court can.
That is paragraph 12, Lordship. The judicial review is not an appeal.
All right, the decision making process and not the decision itself.
Lordship.
Very well.
That is one.
Yes.
And also I'll be relying on, but I'll be slightly handicapped because I don't have the copy of this judgment. Lordship, I'll provide officers by the course of the day, Lordship. This is one judgment that has been very recently been asked by this Honorable Chief Justice, Division Bench, Lordship, where it has, the analysis behind it, it has been passed in MAT 2290 of 2024, Lordship. MAT 2290 of 2024, delivered on 9 July 2025. Union of India and others versus R. Kasivelu.
Okay.
Kasivelu. Lordship,
Relying upon Gunasekhar judgment.
Sekaran, Lordship, I will be relying upon paragraph 13, Lordship.
So that must have been considered by DB. That's why we are asking.
No, this is on the basis of this analogy is on the paramount discipline required in the paramilitary forces, Lordship.
Yes. Yes, there are judgments.
Also,
Banking service, armed forces, the level of scrutiny has to be more stringent.
judgments. One is Gunasekaran and also Om Kumar's judgment. That is the proportionality vis-a-vis with the Wensbury principle, Lordship.
No proportionality. Why you are relying upon? We don't know. There is no question of the court in this case substituting its opinion for anything. What you appear to be aggrieved is that the court has, if we have understood properly, that the court has travelled beyond the contours of judicial review. That is the sum and substance of your case. So it's not a question of the court substituting a different punishment. That's not a case here. Gunasekaran, you may show us.
Seeking days accommodation, Lordship. I'll be.
No, not after so much time. Sorry. Please complete now. Conclude. Gunasekaran, what is the citation? Give us. P. Gunasekaran.
P. Gunasekaran.
Yes. What is the citation? There is a there the Supreme Court has enumerated the circumstances.
Paragraphs where should court entertain and what court should not entertain.
Correct.
Paragraph 12 and 13, if I'm
Very well, we'll consider. We understand what you are saying. Don't worry.
the basis of my process. I'll however provide these two judgments, Lordship, to officers by the course of the day.
Do you please do it? Yes, sir. Yes. Just come to 117. How do you read this? Page 117, how do you read it?
117.
Yes. Ramnath, Sunil Rai and this Kadam. These
Lordship.
are the three persons.
So there is a translation, if you Lordship allow me to, next page.
Yes, you may refer to the translation.
Should I read?
Yes.
Question asked by the present officer on the basis of the statement given by Sub-Inspector X Dharambir Kadam, court witness. The CCTV footage CD given by you as evidence as relating to which gate or post of the plant. Pausing here 1 minute. Before going to the answer of these queries, my lord, if your lordship allow me to 1 minute, there is a 6-tunnel gate. A big plant consisting of several companies, including the Anupam Industries. Your lordship got it? The 6 tunnels, there are number of constables, sub-inspectors and other superintending officials is there to look after the gate. My lord, those are outside. They are observing all the formalities to issuing the pass, and others thereafter they allow the vehicles to get into. And I was deported inside. This is the first day of my service after returning my training. I was waiting. CCTV is there. Backside, left side, I am waiting a right side. I watch in the instrument which has to be find out in the lower portion of the vehicle as there is any unwanted thing is installed or not. Thereafter allow them. Because the initial duty which has been entrusted to the others officials and the other employees, those are allow the vehicles first. Thereafter issue the pass. Thereafter inside the, I was inside.
So what for the pass is issued?
Only to, so for the permit or pass is concerned, to allowing the vehicle to come inside the
So
premises.
therefore, after the out gate, when it comes in the in gate, after looking at the undercarriage of the vehicle, are you not required to see the pass?
Correct.
That you are required to do.
Now question comes, my lord, it appears from the CCTV is the, my lord, appropriate evidence, wherefrom it can be ascertained the which, my lord, subject to consent, don't take me otherwise, lordship, which tunnels this car was coming from.
But no such cross-examination has been done by you to doubt that it is for a different tunnel.
I need not to trouble you, lordship, much. My lord, only so far the evidence part is concerned, and which is the very relevant, which I try to assist your lordship for, my lord, made up your lordship's mind to be take up this matter. My lord, thereafter, my lord, when the vehicle was inside, one constable, he has intercepted this vehicle. Thereafter, my lord, a complaint was lodged before the police authority. Thereafter, my lord, on the basis of the incident which has been occurred inside of the, my lord, gate, a preliminary inquiry report has been prepared by the authority. Now, my lord, on the basis of the preliminary inquiry, which has been part and parcel of the inquiry proceedings, a charge was framed by the departmental proceeding against the incumbent. And on the basis of the legality and the veracity of the charges which has been inflicted upon the charge officers to be proved by ascertaining the relevant documents along with the depositions submitted by the prosecution witnesses, which has been Malud, clearly indicated in respect of the charge. Even Malud, that apart, those are the higher officials. They may be also invited by the inquiry officers for getting or proving the Malud, the allegation which has been leveled against the charge officials. Malud, to cut short of the issues, Malud, except the Malud one Kadam, no other incumbent has given any depositions against the Malud charge officials that he has been either involved or he has been given anything or anything.
Therefore, we ask you, please come to 117. How do you read this? That is the
Lordship.
Kadam's statement is at 114 and 116, 117. These are the two pages.
117 and 114.
114 is a statement and 117 is questions put by the presenting officer.
Question 105. I'm reading 105.
105?
Is English version. Translation.
No, 115, not 105.
114 is a Hindi version and the translation is 105. Kindly.
Not 105, 115.
That is, Lordship, 104 is a statement of, is a PW1, Lordship.
114 and 115. How you are saying 105? 105, it can't be.
105 is a PW1.
Wait.
No, this is not the one. It is one. Ramvi Kadam's statement
Starts at 114.
114, Lordship.
Lordship. I got this. Inner page 84 or it's 115. Lordship.
Yes.
Statement of CISF number such and such 6 Dharambir Kadam, CISF unit, ISV Banpur court witness. Post number such and such Sub Inspector X Dharambir Kadam. I am working for monitoring CCTV in the unit. I was asked to provide the video footage from 18.49 hours to 19.49 hours dated 4/10/2013. In this footage, a four-wheeler is seen entering at 18.58 hours. I am submitting that video footage of the same and this is being filed in the case of exhibit. In this video, footage one car is seen coming to the gate at 18:58 hours and one sentry is seen to open the gate and giving entry. After this sentry is seen closing the gate. My lord, this is a statement which I have been given voluntarily without any pressure. I have given. My lord, if your lordship take trouble to thee, my lord, according to my little experience and my lord, a CCTV where form it can be easily ascertained. First, that the model of the vehicle that has not been mentioned. Number one. Number two, my lord, color of the vehicle, because he is depositing the CD. It can be easily ascertained from my lord, visualizing that the model of the car, color of the car, manufacturing of the car, as well as number of the car. That apart, it can be ascertained easily from the CCTV that except driver, how many persons was boarding in the car.
Yes.
In the said car, it can be also very clearly detected how many persons is sitting in the car. That has also not been mentioning here.
Yes.
So, the allegation which has been leveled against me, and where from it has been detected easily from the CD, but CD camera, it has not been given the actual picture where from it can be determined. Now, so far after this, the sentry is closing the gate. It has also not been clearly depicted the allegations against the charge officials, because there are more than one gate, and the CCTV has clearly tell the actually correct story, but that has not been done it. So, according to my humble submission before Lordship, this statement doesn't corroborating the allegations which has been leveled against the charge officials in respect of the article charge number 1 and article charge number 2. Because I could have been understood, according to my little experience, that a CCTV, 7 except the depositions, a CCTV is one of the important evidence in the modern era. It can be easily detect the allegations which have been leveled against the charge officials. Now, in absence of that, these depositions made by the court witness, by the Dharambir Kadam.
Therefore, again, for the third time, we are asking you, how do you read page 117 and 118?
117.
Yes,
So
we
I'm
have been
reading
asking you.
116 and 117.
118 is the transcript, is the translated version.
Lordship. The CCTV footage CD given by you as evidence is relating to the gate pass of the plant. Gate or post of the plant. The tunnel gate in gate. Here I joining the issue. There are more than one tunnel gate.
All right.
By controversy this, Lordship.
We don't know. He has not cross-examined on this aspect. He has not said anywhere. You have, please, you take your seat. Yes.
Which force members give permissions to the vehicle shown in the CCTV footage to enter the plant? Answer is Ravi Kumar. He's sitting in the computer room. He has been observed that I'm giving the permission, because I don't know how, because I'm not sitting, I'm not working outside the gate where the pass was generally issued. I was inside. It has been evident from the
He is not saying about pass.
Lordship.
There is no mention of pass.
Lordship. Did Constable Ravi Kumar conduct security check of the vehicle before it entered the plant? In the video footage, Constable Ravi Kumar is not seen doing any checking or making any inquiries. Before entering the tunnel gate, how long did the said vehicle wait? The said vehicle before entering the tunnel gate waited for about 10 seconds. Does it appear from the watching the video footage that at the time there was crowd at the tunnel gate? Answer, no. From the video footage, no crowd is found at the tunnel gate at the time. Now, my lord, so for the page 18 is concerned, if your lordship take trouble to the so for the query number 1, query number 3, query number 4, query number 5 is related to the
Here he does not say which person. Says one vehicle and says.
scenario or the picture in respect of the CD which has been given to the
This has to be read. Here is a specify the vehicle. Specify the section. Then in response to 3, he says constable of the check. Check. In the check-in. If not, how cancel it? ये संबंध में प्रवेश की अनुमति किस बल सदस्य ने दी? would have read it. Here he said each something. This concern. He has given on 27/30, 27/11/13, and this is what 28/11. In his presence. Sign. This good sign. The statement is taken on 7. This statement is of 38/11. Till charge officer has refused to do cross-examination. And then the presenting officer puts his question. Is continued. Yes.
now
He has stated your name in response to question number 2 and question number 3.
Lordship, I have marked it. I have told Lordship. So for the my lord, neither he has been deported in the gate.
Hmm?
My lord, the Kadam, Dharambir Kadam, he was either operating CCTV or he was in charge of the CCTV which has been installed in the camera in respect of the tunnel gate is concerned. He is not in the gate. Even his deposition, if your lordship take trouble to the page 115, my lord, he never used my name. He only said after this sentry is seen closing the day. 115. If your lordship take trouble to the
No, how you are saying? He's the CCTV monitoring. He was doing the monitoring.
my lord, kindly come to
There
the
at 115.
I got your lordship, my lord. Kindly come to the page 115.
Yes. I am working for monitoring CCTV in the
Correct.
unit.
Correct, my lord. Now,
Yes.
if your lordship can you take trouble to the last line of the paragraph? And one sentry
Yes, which he later qualifies. Who is that sentry?
coming later on.
Yes.
My lord, because there is a allegation against me that I have not been perform my duty honestly and properly, which leading to a allowing a vehicle inside the plant.
Yes.
He cannot, my lord, he cannot justify the model of the vehicle. He cannot justify the number of the vehicle. He cannot clearly disclose the manufacturer of the vehicle. He cannot disclose how many persons were sitting in the, my lord, vehicle. He cannot justify how many peoples are go inside with the vehicle, 6 or 3 or 1. He cannot. 7 except in page 115, it has been disclosed that 1 sentry. Now, my lord, later on, he has given my name.
Same day, same day. It's on the same day.
I could have been understood. What is the basis?
It is one examination. This page 117 is in continuity.
I got your lordship's point, but I am asking this question to myself. What is the basis? Because CCTV doesn't disclosing these facts. So benefit, rather I could have been asking this question to myself. What is the basis? What evidence leading to the? Only somebody told, because they are the, my lord, prosecution witness. My lord, 3 prosecution witnesses there. Suppose nobody clearly depicted my name that I have been. This
Yeah. Yes.
now, my lord, so for the article of charge number 1 is concerned, if your lordship deal with this matter, that allegation against me that I have been given permissions to a vehicle to get inside. My lord, I am inside deported by the higher officials to be look into the matter. Not the outside of the vehicle when the car is waited for 10 seconds, thereafter got into the vehicle in the premises, thereafter my part to check it. So for the permission, I am not the authority to give permissions to anybody.
There is no such article of charge that you have given permission.
My lord,
The article of charge is that you have not checked.
if your lordship take trouble,
Please read article of charge number 1.
the entry of the said vehicle, number such and such Constable Ravi Kumar was detailed for duty at tunnel gate number B, shifted 4/10/2013 from 13 hours to 21 hours. During his duty hours, a light motor vehicle bearing registration number
No,
such
no,
and such.
article of charge, come to page 87. The article of charge is at page 87.
I'm reading 88, sorry, Lordship. Got into the plant premises about Atho without security check, including
Correct, that is the allegation. It's not an allegation of
check
giving any
into the
pass or
entry
permission.
pass, entry pass oblique permission,
Yes,
entry pass or permission of the said vehicle as well as its occupants.
yes, without checking the pass, not issuing the pass. It says without checking and without looking at the pass. You have not done either of the two things. We don't know from where you are getting this article of charge that how he has issued the pass. That's not the allegation. Allegation is on your guard, this vehicle has entered, did not check the entry of light motor vehicle number so and so, and vehicle got entry without security check, including checking of entry pass. Both these things you have not checked. There is not an allegation that you have permitted or you have given the pass. That's not the allegation.
Now, so for the page 117 and 118 is concerned, so for the depositions Kadam is concerned, where form it can be revealed.
All right. So what is the finding on this point by the Honorable Single Judge? Now let us see.
Lordship take trouble to the starts from page 289 is the order.
Paragraph 32 and 33.
Well, should I proceed?
Interim order.
Each of the code.
Say full back. That only story. Simple. Why I'm saying Manan,
Yes.
Lord, I think your lordship gone through the judgment passed by the trial court.
Yes. By the honorable single judge, not tribunal.
Lord, there is no tribunal, single judge.
Yes.
I need not to be trouble you much, lordship. Before coming to the court, my point of argument before the trial court, which has been followed before lordships here also, that the proceeding which has been initiated and conducted by the authority without having any evidence. First point of argument. Second point, that in the preliminary inquiry, they have been relied by the inquiry officers, but no copy of the preliminary inquiry has been given to the petitioner. Number two. Number three, if your lordship take trouble,
No, that copy has been given to you. Come to page 89.
I'm coming. I'm coming, lordship.
Both the statements of preliminary inquiry have been given to you.
Page 89.
Yes. Statement number so and so of Constable Ramnath during preliminary inquiry is given to you.
This is the depositions made by the PW1 and PW2.
No, it says preliminary inquiry. By ignoring it, it will not vanish. It is there.
Their depositions during the preliminary inquiry part is concerned. Thereafter, a preliminary comprehensive report was prepared by superior officers. And
That is not considered. That has not been
I'm
considered.
coming.
Yes.
That leading to the authority to form their opinion, and
That we don't know. No, nobody can go into the head of the authority. You said preliminary inquiry not given. That has been given to you.
Well, this is not the preliminary inquiry. This is the depositions of the constables.
In your, sir, please read that. Please read what it says. Please read what it says. Statement number.
Statement number 911403019, Constable G.D. Ramnath, recorded during preliminary inquiry.
So,
this is the depositions made by the my lord Ramnath
before in the preliminary inquiry, you are saying it has not been given. This has been given to you. The other statement, Sunil Roy, preliminary inquiry, that has also been given to you.
Perhaps,
Apart from this, no material has been considered by the authority.
my lord, perhaps, my lord, I am not clearing to lordships, my lord.
Yes, you are not clear at all.
Lordship.
Yes.
I try to assist your lordship in a
Yes.
manner. That incident took place.
No, don't go on history. When you make a point, then you will go back to history. You said preliminary
not to-
inquiry was not given.
My lord,
We are saying preliminary inquiry statement has been
inquiry-
given.
my lord, preliminary inquiry reports.
Report has not been
depositions during
relied
the-
upon. Not relied upon, not required. All right, we will
Yes,
consider.
They have relied. They have relied.
No,
I'm coming, lordship. Kindly come to the page. I'm coming.
Consist of three annexures, lordship, which you also section
I'm relying your lordship.
3.
please, you don't, when you were arguing, he has not said a word. Please don't do this. Don't disturb. Please. You will have your chance to reply. Yes.
My junior friend.
No, he will have his, he has to. This is how he will learn. You please wait. We will ask you. Let him say what he has to say.
I'm referring your lordships. Preliminary inquiry report, which has been mentioned in inquiry report dated 5th February 2016.
Cross, where is it in the inquiry report?
Your lordship.
Come to that portion where the inquiry report has come.
Lordship. Lordship.
Continue.
Find it, we'll continue.
Origin side, listed matter underwriting appeals from orders serial number 1 and 2 Sajal Datto.
But 75 will be volume. Volume 18. ঠিক আছে এক্সিট পলিসিটা My lord, on the last occasion, my lord, I was showing you lordship's, my lord, page 575 on which reliance was placed by the appellant at volume 18.
Complied. 24 and 25 at page 575.
Yes, ma'am. Yes. Well, kindly come to page 575 once. That they had relied on, my lord, paragraph 39B, foreign investment. Approval will be given for direct foreign investment up to 51%. Direct foreign investment. Well, kindly take note of the language used.
Yes.
Direct foreign investment up to such and such foreign equity in high priority industries, Annexure 3. There shall be no bottleneck of any kind of etc. etc. Now it speaks of, my lord, direct foreign investment in those high priority industries where, my lord, the hospital does not feature. Now kindly come to page 580, which they have possibly relied on. On the right hand column, clause 3, investment in priority industries under 100% scheme. NRIs, OCBs are permitted to invest with full repatriation benefit up to 100% in the issue of equity share of or convertible debenture of a private public limited company. Again, my lord, investment. Bringing in money. And then kindly come to page 585.
Sorry.
Oh, I'm sorry, my lord. Kindly once come back to page 580. May I read that out, my lord? I was possibly missed it, man. NRIs, OCBs are permitted to invest with full repatriation benefit up to 100% in the issue of equity shares or convertible debentures of a private public limited company engaged in or pursuing to engage or proposing to engage in high priority industries listed in Annexure 3. To the statement on industrial policy dated 24 July 1991, Reserve Bank will grant approval to such proposal provided the contributions received from NRI OCBs towards equity shares, convertible debentures, covers the foreign exchange requirement for import of capital goods. Foreign exchange, so my lord, the money has to come in, not the goods. Foreign exchange requirement for import of capital goods, if any. The plant and machinery proposed to be imported must be new and not second-hand. So with that foreign exchange, whatever plant and machinery was to be imported, those were required to be new and not second-hand. For my lord, implementation of this scheme, which was on repatriation basis. Ours is not a repatriation basis. In fact, my lord, it would appear that it was the permission was granted for second-hand machine because my lord on non-repatriation basis because those were second-hand. Now kindly come to page 585 once. My lord, Reliance was next place, my lord. Page 585, clause 24 and 25. Notwithstanding anything contained in paragraphs 22 and 23, second-hand capital equipment and any other second-hand goods shall not be imported unless permitted by this policy or in accordance with a license issued in this behalf. That was permissible. Then 25. All second-hand capital goods having a minimum residue life of 5 years may be imported by the actual user. It was not, my lord, pausing here for a moment, it was not, my lord, imported by the actual user. Without a license subject to actual user condition, the actual user shall furnish to the customs at the time of clearance of goods a self-declaration to the effect that the second-hand capital goods being imported have a minimum residual life of 5 years. In the prescribed form as given in Appendix 11 of the Handbook of Procedures, if the CIF value of second-hand capital goods being imported is ₹1 crore and above, the importer shall also furnish to the customs at the time of clearance of goods a certificate from an internationally reputed inspection and certification agency to the effect that the purchase price is reasonable. Now, my lord, kindly in this context, my lord, I had also
Thereafter, you had referred to page 595.
595, my lord.
Yes.
There was a change in it.
You had said that none of these proposals are regarding 39B3.
Kindly once, my lord, kindly look into, my lord, 595.
Yes.
This is of 1994.
Yes. 3194. 3194.
1994. Kindly come to clause 2 or the first one, my lord, at the top, proposal from Mrs. Pranab Brothers Private Limited for issue of equity shares to NRI against direct import by, kindly take note, against direct import by NRIs of second-hand capital goods under 100% scheme of repatriation basis, on repatriation basis. Then kindly come to clause 2 at the bottom. The specific issue raised in these cases are capitalization of direct payment, kindly vomit and come to Roman 3. Repatriability of such investment by NRIs against direct payment of imported machinery which are second-hand equipment. And then kindly turn the page. 596 is the typed copy, kindly come to page 597. On these issues, RBI may take action as follows. Government of India have no objection to the capitalization of payment made by NRIs directly for import of capital goods, B, in those cases where such direct payment is for import of new capital goods, The equity participation may be permitted on repatriable basis. C, in all such cases where the amounts are paid directly by NRIs against import of second-hand capital goods, the investment is permissible only on non. And the last paragraph, 4, Reserve Bank of India may consider this and similar other cases on the basis of government's decision indicated above. আমায় ওই এটা দাও না হ্যাঁ 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 হ্যাঁ
The wrong act was available on the last day.
I shall come to that. I'm sorry, madam. There was a mistake on our part. Okay.
'92 Act.
Yes. We are concerned with this. They kindly come to the bottom of the first page. This act may be called Foreign Trade Development Regulation Act 1992. Then kindly turn the page. Clause 2, D. Director General means the Director General of Foreign Trade appointed under Section 6. Kindly turn the page. Section 5. The central government may from time to time formulate and announce by notification in the official gazette the export and import policy, and may also in that manner amend that policy. Then 6. The central government may appoint any person to be the Director General of Foreign Trade for the purpose of this act. The ballot kindly come to the next page, ballot, section 11. No export or import shall be made by any person except in accordance with the provisions of this act, the rules and orders made thereunder, and the export and import policy for the time being in force. So it is governed by this act. Kindly turn the page. Or my lord, kindly come to ballot 2, subsection. When any person makes or abates or attempts to make any export or import in contravention of any provision of this act, or any rules or orders made thereon, or the export and import policy, he shall be liable to a penalty not exceeding 1,000 rupees or 5 times the value of the goods, in respect of which any contravention is made or attempted to be made, whichever is more. Then kindly turn the page. Where any person on a notice to him by the adjudicating authority admits any contravention, the adjudicating authority may, in such class or classes of cases and in such manner as may be prescribed, determine by way of settlement an amount to be paid by that person. A penalty imposed under this act may, if it is not paid, be recovered as an arrear of land revenue, and the import-export code number of the person concerned may, on failure to pay the penalty by him, be suspended. Then, my lord, 5, where any contravention, etc., then kindly come to 12, section 12. No penalty imposed or confiscation made under this act shall prevent the imposition of any other punishment to which the person affected thereby is liable under any other law for the time being in force. 13. Any penalty may be imposed or any confiscation may be adjudged under this act by the Director General or subject to such limits as may be specified by such other officer as the central government may by notification in the official gazette authorize in this behalf. And then, my lord, 15 is the provision for appeal. It's not required. Then kindly come to 16 also. Provision for division, the central government in the case of any decision or order not being a decision or order made in an appeal made by the Director General or the Director General in the case of any decision or order made by an officer subordinate to him may or his own emotions or otherwise call for and examine the records. When input and export was governed by this. And my lord, Reserve Bank of India, my lord, had no role to play, my lord, so far as the import of this second-hand machineries were concerned. That was, my lord, solely, my lord, the lookout of, my lord, the Director General. And none else. None else.
So if at all there is a
If there was a violation, my lord, the customs authority, they were there and the customs clearance was done. And my lord, interestingly, my lord, as observed by the Supreme Court also, that my lord, all these machines were, my lord, taken by the hospital, the customs clearances were obtained by the hospital or the, yes, the hospital. Machines were used and then as observed by the Honorable Supreme Court, that when, my lord, the hospital was flourishing, then, my lord, the disputes arose. Now, my lord, kindly take my compilation once, my lord. 225. Or volume 1 টা দেবেন ওখানে kindly once come to, my lord, page 166. I had placed this before your lordships. Page 166, volume 1. The approval was taken. Page 166, kindly come to, this was
the application made in 93 by the company.
By the company. And signed by, kindly come to page 175. I had shown this, my lord. I know I am repeating, but my lord, I just thought, my lord, that I should show this again. It was signed by Shojol.
When there was no dispute.
And on the basis of this, the approval was granted by the authority. And that is at page 176. Yes. Kindly check whether the second compilation volume 2. The order of Justice Ajoynath Ray was by Lord shown. I had also shown that, but the order was shown by Lord. But before your lordships that Justice Ray had also taken note of independent right of Shogul, who was the petitioner number 2. Now kindly once look into the order, page 225. May I hurriedly go through the order, my lord, once. The writ application arises out of certain permissions granted by the Reserve Bank of India on such and such, withdrawn by it on 2nd June 1997 and by it on 6th March 1999. The approval is in regard to issue of a large block of shares to the respondent number 4 and an NRI gynecologist in New York. The consideration for the block of shares aggregating to some 40% of the share capital of the company was transmitted to India in the shape of various items of gynecological testing machinery. This arrived at Calcutta sometimes in 1994. In the beginning, the Directorate of Industrial Affairs was approached for import of new equipment, but it appeared that thereafter the parties represented to the authorities that the equipment was demonstration model second hand. Kindly take note, parties represented. On this basis, the RBI permission would have to be, if at all, on a repatriation basis. Kindly take note. That was the contention of the
Non-repatriation.
non-repatriation. I'm sorry. That is the contention, and that is exactly what was done. The second petitioner and the fourth respondent were brothers. They are engaged in company litigation before the company law board also. An important issue there is whether the 40% block of share is to be issued or not. There are allegations and counter allegations to the effect that the equipment transmitted from USA was good and usable, and on the other hand, it is alleged that these have not proved to be of such use.
Much use.
Sorry, of much use.
Yes.
There is some statement on record that after large-scale repair, some equipments could be used. Without the approval of the Reserve Bank of India, the issue of share cannot go through. Thus, whatever decision the company law board or any other appropriate authority might take on the merits of the issuance of shares, the first hurdle requiring of the Reserve Bank permission has to be crossed in any event. In the report, I am not concerned with the factual dispute and the value or usability of the machine imported into India. This court is concerned with the validity and reasonableness of the orders passed by the Reserve Bank functioning within the four corners of the law. It is alleged by the parties that each of the three orders of the Reserve Bank of India was passed behind the back of either the one party or the other, depending on which order favored which party. It is quite clear that no hearing in the presence of one another was given by Reserve Bank of India in regard to those approvals, although at least from mid-1997, the existence of disputes between the two governments should have been crystal clear to the authorities. There is a problem in the 22nd 1997 order in that it speaks of non-repatriation in the beginning and export of shares slipped at the end. The 2nd June 1997 order seems to proceed on the loss of directorship of NLI whose non-attendance of meeting by the party must have happened earlier also. The lost order of 1999 goes so far as to direct issuance of shares which no part of the jurisdiction of RBI. In this view of the matter, the above communications by the RBI regarding approval have to be stayed and an order has to be passed by the appropriate officer of RBI after hearing both the contestants. The order and observations are without prejudice, etc. The respondent number so and so shall grant a personal hearing to the writ petition. My lord, it does not, my lord, with greatest of respect, the order does not, my lord, take into consideration or acknowledge any independent right of sojourn. Now, my lord, then, my lord, the order passed by RBI, which is at page 229, was passed. The initial order. The initial order, which was, my lord, they participated before the executive director. I had shown this. And when the executive director had passed the order, my lord, then it was challenged, saying that the executive director had no reason.
This is as a consequence of the order passed in the writ.
The first read.
525.
Kindly once come to page 229. By an order dated 22nd March 1999, the Calcutta High Court in writ petition number such and such has directed the Reserve Bank of India, the third respondent in the above writ petition, to grant a personal hearing to the petitioners, Ruby General Hospital, Calcutta, not my lord, Odu, and the fourth respondent, Dr. K.K. Datta, and make and publish a reasoned decision in the matter of approval for issuance of shares, etc. Then kindly come to paragraph 2. Starting his submission, the advocate for petitioner RGA, Ruby General Hospital, he makes his submissions. Well, and I am not showing all this. Paragraph 3 at page 233 records, my lord, the submissions made on behalf of my lord Dr. Datta K.K. Datta. Kindly come to page 235. I have given a patient hearing to both the parties who have advanced their arguments in support of their case at length. And I have also gone through the submissions made by both the parties. In this case, I find that the banker has a rather limited role under the provisions of the Foreign Exchange Regulation Act 1973, the Act in the dispute between the parties. Section 19 of the Act initially requires any person which would also include a company not to issue any share to a person resident outside India, except with the general or special permission of Reserve Bank. Under the existing policy of the Reserve Bank, permission is given to the Indian companies to issue shares on repatriation basis against the capitalization of import of new equipment or machinery. However, if such equipment or machinery is second-hand, Indian companies are given permission by Reserve Bank to issue shares only on non-repatriation basis. The permission granted to the Indian company to issue shares to the persons resident outside India is also treated as permission to such persons resident outside India to acquire or hold such shares under section such and such. Admittedly, in the present case, the imported equipment was second-hand, Therefore, Indian company Ruby General Hospital have Reserve Bank's permission to issue shares to such and such. Dr. K.K. Dutt. I therefore vote that the Indian company Ruby General has the approval for allotting. Now, my lord, I did not place before your lordships a submission made on behalf of my lord Ruby, which the submissions are recorded in paragraph 2, starting at page 229, and it goes up to page 233. These submissions, my lord, do not record any personal grievance of Shoghi. Yes. No personal grievance of Shajol was agitated. The point which is now being sought to be, my lord, canvassed before your lordships, that, my lord, issuance of share would, my lord, prejudice Shajol personally, my lord, was not there before Reserve Bank of India. As I have submitted, my lord, they participated, then they challenged this order when it went against them after participation. It came up before another single judge of this honorable court at page 239. Then dated 23rd February 2004, I had also placed this. Kindly come to page 240. The quoted portion of the order of Justice Ray. Last paragraph. The respondent number 3 shall grant a personal gain. Page 249. And now kindly come to page 241, the submission made. The senior advocate appearing with his learned junior, drawing my attention to the aforesaid order of the constable of the previous written submission. The mandate of the court was upon the aforesaid respondent to decide the matter. My lord, with greatest of respect, when somebody else was hearing the matter, my lord, they did not raise any objection. Be that as it may, the court entertained this writ. Was upon the aforesaid respondent to decide this matter. He has not carried out mandate. Rather, it has been done by another official, maybe higher in rank, without approval of the court. He says in simple terms that the said officer has no authority or jurisdiction, as this court did not ask him to decide the matter. Then his further contention is that when the law requires a thing to be done, etc., then kindly turn the page. Submission made on behalf of Reserve Bank is recorded. Then kindly come to page 243. My lord, submission made on behalf of, my lord, the Dr. Datta are recorded. Then 245, kindly come to the last paragraph. I simply record that the executive director had no authority or jurisdiction to pass the impugned order, as he has expressly recorded that the impugned order is sought to be passed pursuant to the order of Justice Ray. It is amazing how an officer of a statute, teacher, It is amazing how an officer of the stature of the executive director, without having expressed authority from the court, could take up the matter, etc. And it was, my lord, sent back. That your lordships will find at page 248. Last but one paragraph, accordingly, I hold that the order passed by the executive director is of no value and the same is non-est, etc. Therefore, this court will not waste time. Next page, 249. The respondent number 3 is accordingly directed to carry out the order of Justice Ray, since the first order passed by the respondent number 3 may be placed before the court itself. Now, this was again. এখানে কিছু নেই তো। No argument was advanced even there, even before Justice Sengupta, about, my lord, the personal right or, my lord, infringement of personal right of
He has only proceeded on the point that the appropriate authority has not dealt with it, and he has specifically said, I am not touching anything else.
that was not even urged. My junior rightly points out, my lord, that he did not urge because he was in the helm of affairs at that point of time. Supreme Court order did not come. Now, my lord, next, my lord, kindly once come to the order of, my lord, the Reserve Bank, my lord, 254 and 257, the same volume. Main order is at page 258, my lord, kindly come to that. Even before that, even before the general answer. It's not urged. 258. Kindly come to the first page 258. Background. By an order dated 22nd March 1999, Honorable Justice Ajaynath Ray of Calcutta High Court in writ petition number such and such has directed the Reserve Bank of India, the third respondent in the above writ petition, to grant a personal hearing to the writ petitioners, Ruby General Hospital, Calcutta, and Sri Sajul Dotto, and the fourth respondent, Dr. K.K. Dotto, non-resident Indian investor, on their duly authorized advocate, and they can publish the decision in the matter of grant of approval, both as regards 69 and 29 of the FERA Act 1973. He had also directed in the said order that particular attention has to be paid as to whether the approval shall at all be granted or not, whether the approval shall be on and basis alone, whether there shall be any monetary limit or limit to the number of shares which shall be subject matter of the act. Then, my lord, come to page 259. Records of the hearing on 22nd April 2004 is on. I do not intend to, my lord, place the entirety. Again, my lord, the submissions made before the authority did not, my lord, agitate any personal grievance of Shajja. My lordship can take it from me, my lord, I am not wasting time.
No, we have pointed out earlier also. We have said that even their names have been taken out of by designation. at page 260, you had pointed out that they have all appeared by designation.
And my lord, there was no grievance about my lord infringement of any person.
Yes, yes.
Kindly once come to page 272.
Limited role.
First issue, whether approval shall at all be granted or not. Terms of section 19(1)(d), any person which includes a company has to obtain RBI's permission before issuing shares to a person resident outside India. Then my lord, 19(1)(d) is quoted. From the above, it is clear that any person which includes the company can issue shares to NRI prior permission of RBI for issuance of such shares. Issuance of shares can on repatriation or on non-repatriation basis. RBI permitted issuance of shares on repatriation basis when foreign remittance was received through normal banking channel, or when there was capitalization of new equipment supplied by the NRI. If the equipment supplied was second-hand, then the capitalization of the same was allowed on repatriation basis. Admittedly, in this case, the equipment supplied by Dr. K.K. Dotto were second-hand, and there is no dispute on this point. CIA approval was obtained on such and such, in which non-resident equity participation showed 88.88%. CIA later also states that project envisage import of capital goods worth such and such to be financed out of NRI investment. Governed by the then EXIM policy, in terms of which there was no restriction on import of second-hand capital goods. Thereafter, on 4th November 1993, in principle, approval was granted by RBI for issuance of shares on repatriation basis. During the financial year 1994-95 and 95-96, Dr. K.K. Dotto supplied imported second-hand medical equipment and applied for share against the second-hand equipment. The import of such medical equipment against which shares were to be issued pending RBI permission for the same was reflected in the annual reports and balance sheet of the company for the year ending on such and such. Fact was also known to Sri Sajal Dotto, as he had signed the above balance sheets as director of the company. The above balance sheets also showed income over rupees 100 lakhs from out of the operation of the hospital, obviously with the use of equipment supplied by Dr. Dotto and commissioned by the hospital. The permission granted by RBI dated later dated such and such was on the basis of Ruby General application dated 17 March 97, signed by Dr. K.K. Dotto as the chairman of the company, enclosing there to all the requisite documents. Same was recognized by ECD, RBI, Kolkata. At that point of time, the regional office of RBI was delegated with the power of approval, etc. Again, I had placed this part, my lord, at the top, the import of the equipment was governed by the EXIM policy.
Yes.
And I have shown that. Then, my lord, kindly come to page 275.
In terms of 19(1)(d).
Then, my lord, second issue, kindly look into. Or, my lord, may I please? In view of the above, I am of the opinion that the RBI's permission for issue of shares shall be granted in terms of section 19(1)(d) of FERA to RGHL, Ruby General. The permission granted to Ruby General shares to the person resident outside India shall also be treated as permission to such person resident outside India to acquire or hold such shares under section 29(1)(d) of the Act. Second hand, whether the approval shall be on non-repatriation basis alone. As discussed above, the equipment supplied by Dr. K.K. Dotto were second hand. Company had received and utilized the same for which Dr. Dotto had made payment abroad. Since as per the existing policy of RBI, capitalization of second-hand equipment could be permitted on repatriation basis only. Non-repatriation basis, I am of the view that permission shall be granted for issuance of shares on non-repatriation basis alone. Though there was conflicting claims and counterclaims regarding functioning or dysfunctioning of the medical equipment or its value, etc., by both the parties producing various documents and papers in support of their stand, I am of the view that it is beyond the scope and purview of my investigation to delve into each and every claim and counterclaim. Again, my lord, your lordships can take it from me. There is no whisper about, my lord, infringement of any personnel, as there could not have been. As there could not. Now, my lord, may I show your lordships once, my lord, these two sections, 19(1)(d) and 29.
It's in volume 1.
Volume 1, my lord, this, my lord, only 19 is there. 29 is possibly not there. But that is school level.
19(1)(d) is in volume.
19(1)(d) is there.
Where is volume 1?
Which 2 contains, my lord, 19(1)(d).
Perhaps page 1 if you. Volume 1, page 1.
That's true. But it does not contain section 29.
Only 19.
Sorry for the compilation.
You want us to see 20 also? You want us to see 20 also?
29.
29. 29 is.
29 is not there, my lord.
We are 19, 22, and 24.
Right. Teach. I'm thankful to my learned. Kindly come to 29. Kindly come to 29, my lord, once. Section 29, sir. 29(1)(b). 29(1), kindly come to restriction on establishment of place of business in India without prejudice to the provisions of section 29 and section 47 and notwithstanding anything contained in any other provision of this act or the provisions of the Companies Act 1956, a person resident outside India whether a citizen of India or not, or a person who is not citizen of India but is resident in India, or a company other than a banking company which is not incorporated under any law in force in India, or any branch of such company shall not, except with the general or special permission of Reserve Bank, kindly come to B, acquire the whole or any part of any undertaking in India of any person or company carrying on any trade, commerce or industry, or purchasing shares in India of any such company. That was the only restriction.
So this was the permission under 29(1)(d).
And 19(1)(d), 29(1)(b), and I have shown your lordships the 19(1)(d). That also again, my lord, does not contain any restriction. Now kindly take up, my lord, once, my lord, the writ petition. I would submit before your lordships, that is page 40 of the compilation, first volume. Even in the writ petition, my lord, there is no whisper of any infringement of personal right. Kindly come to page 40.
40 of the compilation or the writ petition? Yes.
Kindly come to the first paragraph. The petitioner number 1 was incorporated under such and such. Then the next sentence, the petitioner number 2 is the managing director and the shareholder of the petitioner number 1, and is vitally, page 42,
Yes, we have it.
and is vitally interested in the management and affairs of the petitioner number 1, and carries on business through the agency and instrumentality of the petitioner number 1. That is all.
And you had said that now after the Supreme Court order, this entire scenario changes.
And my lord, I can hurriedly, my lord, some of the paragraphs, my lord, kindly come to paragraph 2. The respondent number 6 is the elder brother of the petitioner number 2 and is also a shareholder of the petitioner number 1. The respondent number 6 was one of the first directors of the petitioner number 1 and was a director and chairman of the petitioner number 1. The respondent number 6 ceased to be a director of the petitioner number 1 by virtue of the provisions contained in such and such, and the same was duly intimated to the respondent number 6 by the petitioner number 1. By a later date, such and such, the same was also intimated to the board of directors of the petitioner number 1. The copy is enclosed. Then paragraph 3, in or about 31st May 1993, an application was made. By the petitioner number 1 to the Secretary Department of SIA under paragraph such and such of this industrial policy for approval of foreign non-resident Indian investment for establishment of a hospital cum advanced diagnostic facility in respect of the petitioner number 1. By a communication dated 6 August 1993, SIA approved the said application made by the petitioner number 1 for foreign collaboration in respect of non-resident Indian investment for establishment of a hospital cum advanced diagnostic facility center at Calcutta, West Bengal. The said approval provided that foreign equity participation in the petitioner number 1 would be a maximum of rupees such and such on repatriable basis, and envisage import of capital goods by, namely, medical equipment worth rupees 420 lakhs to be financed out of non-resident Indian investment. The said approval was required to be part of the foreign collaboration agreement, etc. Then my lord speaks of the agreement. Then kindly come to paragraph 4 on 7th September 1993. The petitioner number 1 made an application to SIA for amendment of the said approval dated such and such, pursuant thereto by a communication dated such and such. An amendment was made to the approval granted by the letter dated 6 August 1993 by SIA, providing therein that the foreign collaborator would be the respondent number 6 and his other NRI associate. Then kindly come to paragraph 5. Pursuant to the said letter dated 6 August 1993 and 12th October 1993 issued by SIA, the respondent number 1 by a letter dated 4th November 1993 informed the petitioner number 1 that the said respondent was agreeable in principle to the petitioner number 1 issuing equity share and 6% redeemable cumulative preference share amounting to rupees such and such, each to non-resident individuals. A copy of the said petition is annexed. It will be evident from the same that for the issue and allotment of shares specified therein, the respondent number 1 required funds to be remitted from abroad through normal banking channel or paid out of funds held in the investor's non-resident external FCNR account maintained with bank authorities to deal with the foreign exchange. The said communication also provided that only on receipt of funds and before the actual allotment of shares to non-resident Indian nationality of origin, the petition number 1 would have to make an application under section 19(1)(d). Then, my lord, kindly come to the next paragraph. On 1st March 1994, an application was made. Kindly omit that. Then paragraph 7, my lord, pursuant thereto, the loan agreement was made in writing with IDBI. Also kindly omit that paragraph. Paragraph 8 said later dated 30th June, the agreement dated such and such and documents, etc. H9 kindly omit. Kindly come to paragraph 10. Paragraph 10, during the period 4th October 1994 and 20th October 1995, the respondent number 6 caused to be imported by the petitioner number 1 several medical equipments allegedly procured from abroad without ever disclosing to the petitioner number 1 that such medical equipment were second-hand medical equipment. Then paragraph 11, said equipment which were caused to be imported by the respondent number 6 in the name of the petitioner number 1 were outdated, over invoiced, etc. Then kindly turn the page. Paragraph 12. During the tenure of the respondent number 6 as the chairman of the petitioner number 1 and prior to the appointment of the petitioner number 2 as managing director of petitioner number 1, on 9th February 1996, the respondent number 6 failed to ensure compliance of statutory provisions of the Companies Act. Then next page, paragraph 13, information to IDBI. Paragraph 14, further board meeting. Paragraph 15, later issued by IDBI. Paragraph 16, subsequently at a board meeting of the petitioner number 1 on 13th April 96, a resolution was passed that no application would be submitted by the petitioner number 1 to the respondent number 1 for allotment of shares. Then 17, in spite of the aforesaid, in order of January 97, the petitioner number 1 received a letter from RBI. Then 18, in as much as the letter dated 7th October 96, such and such, had never been issued by the petitioner number 1. It goes on, my lord. My lord, I have read the writ petition carefully, my lord. Again, my lord, I would submit there was no allegation that, my lord, this permission, grant of permission, my lord, affects the petitioner number 2 individual. My lord, there has to be infringement of the personal right of the petitioner number 2. That averment is, my lord, completely missing in the writ petition. And now, if your lordships are once, my lord, oh, very well. Follow? No, I think I should place some more paragraphs of the writ petition. My lord. My lord, kindly come to page 128. Kindly come to page 128, paragraph 128. Reliance was placed on this paragraph to show that, my lord, it speaks of the individual right of the petitioner. Paragraph below ball. Paragraph 128, kindly come to, sorry, page 128, paragraph 128, on which Reliance was placed. The respondent authorities in property will pass the said order dated 7th May 2004 have acted arbitrarily and in hostile discrimination of the petitioners. Now, in this context, my lord, Reliance was placed on
Sorry.
57. The order of RBI, I placed that, my lord. No submission was there, my lord, so far as the individual right of the petitioner number 2 was concerned.
They have relied upon paragraph 128, 131, and 137.
Yes, my lord, 131, kindly come to respondent authorities in purporting to pass the said order dated 7th May 2004 have sought to impose unreasonable restriction on the petitioner's right to carry on trade and business, and have sought to unjustly benefit the respondent number 6 at the cost and expenses of the petitioners. No personal right of, my lord, the petitioner number 2 is, my lord, agitated or infringed. Yes, the word used is petitioners, but how, my lord, the petitioner number 2's right is being affected, my lord, there is no whisper. There has to be a specific pleading to that effect. Then kindly come to page 137. Sorry, paragraph 137. Page 129. The orders dated 23rd April 2004 and the order dated 7th May 2004 are vitiated by bias on the part of the respondent number 2 against the petitioners. That is all. It does not, my lord, I would, at the sake of repetition, my lord, yes. Kindly come to the next paragraph, 138. Respondent number 2, in purporting to act as aforesaid, acted in a manner so as to give rise to a reasonable apprehension of likelihood of bias on the part of the respondents against the petitioners. Then paragraph 140. Paragraph 140, the respondent authorities fail to take into consideration the documents filed on behalf of the petitioners with the respondent number 1 on the earlier occasion before the respondent number 5. Though it was submitted on behalf of the respondent number 2 that all such documents and notes of submissions were being relied upon at the hearing held on 22nd April and 22nd and 23rd April 2004. And in this connection, the respondent authorities failed to take into account the report of SGS, the report of doctors affiliated to so-and-so, and the letters issued by the agent and suppliers of the manufacturers of the concerned medical equipment, and letters issued by the doctors of several departments of the petitioner relating to second-hand medical. No whisper, no allegation about, my lord. Then paragraph 141. The order dated 7th May 2004 has been passed with the collateral object and improper motive to benefit the respondent number 6 at the expenses of the petitioners. The case which has been made out, my lord, that issuance of these shares affect, my lord, the personal right of, my lord, the petitioner number 2, the original petitioner number 2, the sole petitioner before your lordship has on it, is not there. Oh. Page 132. Property 140. Sorry. 132, clause E. The respondents number 1 and 2 in passing the order dated 7th May 2004 failed to take into consideration the case of the petitioners as made out in earlier petitions referred to herein above as also notes of submissions filed after the hearing granted by the respondent number 4 and the documents filed with the respondent number 1 and subsequent to the hearing granted by the respondent number 4, and also in passing the order of 23rd April and acting in a manner aforesaid, denied to a petitioner the right to refer to such books of submissions and documents filed with the respondent number 1 and to file the same separately with the respondent number 2, and also failed to give an opportunity to the petitioners to deal with the submissions made in the notes of submissions filed by and on behalf of respondent number 6. Such circumstances, the petitioners being aggrieved by the two orders dated such and such hereby apply to this honorable court for the relief spread for hearing. Kindly come to page 153. Sir, kindly come to ground number 43 at page 153. For that the respondent authorities in purporting to pass the said order dated 7th May 2004 have sought to impose unreasonable restriction on the petitioner's right to carry on trade and business, and have sought to unjustly benefit the respondent number 6 at the cost and expenses of the petitioners. Then kindly come to page 157. Ground 58. For that the respondents number 1 and 2 in passing the order dated 7th May 2004 failed to take into consideration the case of the petitioners as made out in the two earlier writ petitions referred to herein above, as also the notes of submission filed after the hearing granted by the respondent number 4. And এটা তো বডিতেও বলেছে after hearing granted by the respondent and the documents filed with the respondent number 4 and subsequent to the hearing granted by the respondent number 4, and also in passing the order of 23rd April 2004 and acting in a manner aforesaid, denied to your petitioner the right to refer to such notes of submissions and documents. This is there in the pleading also in the paragraph, and there 143, the petitioners have no other alternative or efficacious remedy. Now, my lord, if I am hurt, if I am aggrieved by an action, now, my lord, I have to go to the court and tell the court that, look here, this action of yours has prejudiced me in this manner. They have to say that. Somebody has to utter that. Where is that? If I may ask myself the question. It is not there only because, my lord, lordships have seen, my lord, when the writ petition was filed before, my lord, the Supreme Court order. Interestingly, after the Supreme Court order, a board meeting was held in which a decision was taken that, my lord, Ruby will apply for deletion of its name. That was done. On the basis of that, an order was passed on 30th November 2006. That order was never challenged by Shojol. Shojol did not, at that point of time when the order was passed, either at that point of time or even thereafter, did not challenge the order. Did not say that, no, this order cannot be passed because it prejudices my right. Now, even after that, Shojol did not, my lord, try to amend the petition. He was the sole petitioner. His permission was not required, my lord, for amending the petition. I was reminded.
Yes, we are also reminded. There is a obituary reference actually. So we'll continue tomorrow. Second August.
Can it be on 7th, my lord?
Can be. Can be.
Shall be obeyed.
So you expect to conclude on Sundays for further consideration.